A judge can split your house, your car, your pension, your VA disability check. Zero of it. At the desk with us, Professor Beaulieu, who studies exactly where a VA check is shielded and the one place it still is not. Here is what almost nobody gets right. One kind of claim walks straight through that shield, and it is not the one most people brace for. Pin that.
Well, where does that protection even come from? One line in federal law does most of the work.
Section 5301, Title 38. It shields your benefits from creditors and it cannot be seized.
Careful with the word garnish though. A general creditor cannot garnish it. A support order is a different animal, and we will get there.
So put a plain name on it. In a divorce, this check is not marital property. It is not on the table to divide the way a pension is.
We already ran this experiment in the courts. Congress wrote the Uniformed Services Former Spouses Protection Act. It lets a state divide military retired pay but only disposable retired pay, and it carves the disability waiver right back out.
And Howell versus Howell, 2017. Supreme Court, 8-0. A judge cannot make you pay the X back for the part you waived. That settles it.
And the reasoning is not an accident. That money replaces a body, not a paycheck. The law treats it as personal to the veteran, which is exactly why the property side of a divorce cannot reach it.
You do not have to take our word for it. That is the actual statute printed on the page.
Picture the courthouse steps. Property gets divided inside. Your disability check never makes it through the door.
And this is not a loophole. 9 times out of 10, when a veteran panics that an X is coming for the disability check itself, the property side of the case simply cannot touch it. The fear is aimed at the wrong target.
Which is a real relief for a lot of people watching. But the paperwork tells a fuller story.
The chat is already pushing the question everyone types. Can an X ever reach that check?
It can, just never through the property fight.
One thing before we go deeper, va.professorerica.com has free plain English guides on all of this. No sign up, use it. The shield keeps the creditors out. It never turns a veteran into an island.
Different rules, different money.
Let me pause for just a second because this genuinely helps. If you are getting value here, hit that like button, then subscribe and ring the bell. It costs you nothing, and it is the single biggest thing that keeps these videos coming.
Different animal entirely now. A judge cannot split it, but a judge can still make him pay from it.
And this is the claim I told you to pin, not a creditor. Not the property split, child support.
And a state court does it. Not the VA.
Run the switch then. Credit card debt bounces off the shield, but child support, does that get through?
It gets through. Rose versus Rose, 1987. The check is meant for the veteran and the family.
Change it. What if that VA check is the only money he has? No job, no other income at all?
Then the court can still hold him to it. The money was never only his to begin with.
That part scares me a little. Grocery money on both sides.
Before anyone gets comfortable, here is the question that trips people. Does the VA itself garnish the check and mail it to the X?
Two things to untangle there, and I'm leaning in for this one. The VA does not garnish for support. A state court enforces it against him. The VA is not picking sides.
And here is the trap. If you stop paying support because you think the check is untouchable, that backfires hard.
Watch the myth fall apart. People picture the wrong machine here.
The myth, the VA pulls it and hands it over. The reality, a family court orders it and the check counts as his income.
Take a composite case. A check arrives, full disability. He reads that it is protected from creditors, so he stops sending the support payment.
Thinking he is safe.
For a few months, sure. Then the family court finds him. Back support plus the arrears enforced against the same check he thought no one could touch.
The shield stopped the credit card company. It was never built to stop his own kids. Courts have said so for, 40 years? 39, since 87.
Quick gut check. A credit card, a hospital bill, an ex splitting property, an ex owed child support, 4 claims. How many actually reached the VA check? Erica, gut number.
2. Support and the hospital.
1. Only the support order gets through because for that order the check counts as income. That is what this simpler than that. It is a sieve. It catches the creditors and lets the child support drip straight through.
Same for alimony. Court-ordered spousal support reaches it too. Court-ordered, I should say, not a handshake.
Well, I would have said the sieve catches almost everything and lets almost nothing through.
Other way, Lewis. It blocks almost everything. Support is the narrow thing that slips through.
You are right, I had it backwards. It blocks the many and passes the one.
And that narrow thing is not small to the family on the other side. I think about it over that first quiet coffee before anyone is up. It is somebody's whole month.
But that is only the disability check. Coming up next, there is a second pot in a military divorce that plays by completely different rules.
Which raises the one question that decides a retiree's whole case. What about the retired pay he gave up to get this check? Is that shielded too? No, it is not shielded the same way, and that is the tricky part. Professor Beaulieu is back with us for exactly this.
Here is the piece most people miss. A retiree has 2 pots. The disability check we have been protecting, and the retired pay behind it. They do not follow the same rule.
Right. So which pot can a court actually divide?
The pure disability check stays shielded. To reach it, a family still has to go through a support order in state court.
Think of it like a phone, actually a family phone plan. 2 lines, 1 bill. The retired pay is the main line you can transfer. The disability check is the locked line. The waiver is the switch that moved the minutes over.
Okay, but on a phone plan you choose to move a line. Does the veteran choose here, or the law? That is the crack. You do not choose. A federal waiver flips it, and that is what drops the disability out of reach.
Plainly then, the retired pay you waive can be divided as retired pay. What it became cannot be. Same dollars, different rule.
And it splits once more. Restored as CRDP, it is retired pay divisible. As CRSC, combat related, it is not divisible, though a court can still.
Hang on. Which one is the combat one again?
CRSC, combat related. And though a court can still garnish that CRSC for child support, no ex can take it as property.
To use Cynthia's word, the sieve holds. Support drips through CRSC. Creditors, the ordinary kind do not.
You keep saying apportionment. In one sentence, what is that?
It is the VA splitting one person's benefit and paying a slice straight to a dependent.
So the ex just files that form and the VA starts carving up his check.
That used to be the move. Here is what changed under people's feet. For decades, a spouse or child could file VA Form 21-0788 and ask for a need-based apportionment. On February 9th, 2026, the VA stopped granting them.
So the VA just stopped taking those?
For need-based cases, yes. The VA's own reasoning is that a state family court is better built for a support fight. More tools, more access to the real finances. Existing apportionments keep paying, but new need-based ones are off the table.
That is the actual form. Look at what it is asking for.
VA Form 21-0788, the apportionment claim. It used to hinge on a money section, the veteran's award against what the family says it needs. That is the need test the VA just walked away from. So today the form asks only for the narrow reasons that still qualify. So the VA does not do apportion.
It still does, just not need-based anymore.
Fair, only incarceration. or an institutionalized vet now. The everyday case moved to the courthouse.
And the family is already receiving an apportionment. They
Keep it. Exactly. Only new need-based claims are touched.
Exactly. Existing cases are safe.
So here is the whole thing in one breath, because the pieces move fast. If you are the veteran, your pure disability check is shielded from creditors and from the property side of a divorce. That part is solid. If you owe child support or alimony, a state court can still reach it, and refusing to pay because you think it is untouchable is the fastest road to a contempt order. And if you are the spouse or child who used to count on the VA carving out a share, that door is mostly closed now. Your fight moved to the family courthouse.
If you are in a divorce right now, pause here and grab two things: your VA award letter and any support order. I will wait.
Whole thing on one board, 2 columns, shielded on the left. What a support order reaches on the right.
It is like my orchid shelf. I over-research it and underwater it. People over-worry the divorce split and underplan the support order. The risk is the one they ignore.
So here is the honest verdicts. Nobody can hand your VA disability to an ex as property. That protection is real and you should not let anyone tell you otherwise. But if you owe support, it can be reached, and honestly, it should be. The check was always meant for the veteran and the family both.
One caveat that matters. This is the federal frame. Your state's family court may read the details differently. This is education, not legal advice.
Professor Bilu, thank you. The February change alone was worth the seat.
Genuinely, you saved a lot of people a bad assumption.
Anytime. Just know which bucket you are in.
If this cleared something up, hit like and subscribe. It helps us keep making these for veterans and the families beside them. So tell me, which bucket is your money in? And did anyone ever explain the difference before today? Take care of your paperwork and take care of each other. We will see you at the next desk.